So I want to spend a little time talking about social media and the law. Several questions have come up in general just about the legal aspects of social media, and what I'd like to provide sort of an update of where we are right now. There's been some major changes in the last few months that will impact some of the slides. I am a licensed attorney, and that means absolutely nothing. I typically spend most of my time in marketing, but I do stay up with continuing legal education on some of these things. So this is not construed as legal advice, and if you have any specific issues, you certainly want to seek the good counsel of an attorney. So that said, I'll jump in. This is sort of starting with the end in mind, and what I want to say is it's the single most important aspect of any legal aspect of social media and the involvement within digital. But I don't want to actually go into the policy until the very end of this conversation. So I'm just going to leave that with the point that we're going to start with the policy. Probably the most important aspect of one of the largest infringement areas within social, within blogging, within any of our digital sphere is going to be copyright infringement. And so really looking at what specifically you can and cannot do, and a lot of this will be governed somewhat in fair use in USC Title 17. And so, I think one of the most succinct ways to state this is copyright's not an absolute. Potato chips are an absolute. If this was my potato chip, then it's not yours. You can't touch it, eat it, or use it for any reason whatsoever. So this is very convoluted when we really look at copyright. It's like, what am I holding on to? Is it the words? Can I copyright individual words that are out there? Is it the assimilation of the words? Is it the written work that's out there and that I'm trying to protect? So back in law school, we would always talk about a bundle of sticks, that those bundle of sticks really are your rights. They're not clearly defined as any one thing, but they are a number of rights that you have that are sort of bundled up. And that's sort of the way that intellectual property is. And really the most important thing that I think to keep in mind is copyright is protected, whether it's trademarks or whether it's copyrighted information, whether it's copyrighted images. All of these things are held and guarded by the copyright owner, and they're only as good as you are willing to enforce. And so setting up boundaries and setting up different methodologies to be able to keep you apprised of people using your copyrighted information without permission, it ultimately falls on you. Once you have that, you can certainly have them to cease and desist, and you have some legal options and even some rights there. And so these rights, they attach at publication. So as soon as you put a blog post out or as soon as you publish a picture, then you have those rights. So usually you want to first kind of start with the request of the removal. If that doesn't work, then you can use a cease and desist. And if you use a cease and desist and send that to a web server, they will take it down promptly. In my experience, that certainly seems to be true. And then finally, you can sue for any damages, any revenue loss that you had because somebody was stealing your image, etc. Typically, it comes down to the cease and desist. You don't really see anything beyond that. So that's in the hands of the copyright holder. If you're the copyright infringer, you absolutely have to be aware of what you're infringing. And so really thinking about this when you're using content, linking to somebody else's content is one thing. Going and stealing whole articles from them is entirely a different matter. And just like you've been taught in school, if you say more than a few words, you want to quote that and cite it. If you say a longer number of words, you block quote that. You footnote it and you put the information in there. It's really a matter of not just taking someone's content and passing that off as your own. And so I think the academic surrounding copyright certainly applies in with that information. The other thing to think about is the license that you have when using copyrighted information. And so one thing that I would suggest is looking at the Creative Commons license. You can typically use Creative Commons licensing for free as long as you attribute the author of that material in your publication. And so it's typically, in a lot of blog posts that I use, I'll go into Flickr. I will search only for Creative Commons licensed images and then put those into the blog post. But when I do that, I typically use Flickr's short code, which pulls the alt tag and the image in. It attributes the image itself to them, and then I always, out of courtesy, put another link at the end of the post attributing the authorship and the creation of the image. You always have to be aware of this. You can go to royalty-free sites like Shutterstock or Getty Images, but anytime you use those photographs, there is a license that you're granted to use that photograph. And so you have to be very careful about what that specifically means. Can you reuse that in different publications? Is this a one-time purchase? So just be very, very aware of exactly what you're using and how you're using it. So in the realm of academia, there are certain fair use exceptions that you have to copyright, and so typically a big deciding factor is whether the content that you're using is commercial in nature or whether it's for nonprofit or educational purposes. And so certainly within academia there's a lot of latitude given in this area. If I'm really using this content for education, then I have a little more leeway. If I'm using it for a commercial application, and this comes up in blogs quite a bit, regardless of whether it is the primary commercial blog or whether it's a secondary blog or a product specific blog, if it's being used in commercial in nature, copyright holders will protect their rights at a very high level. So just keep that in mind. The other factors consider the nature of the copyrighted work. What was the medium of it? What was it presented to do? Is it a paid work, for example, that's then being passed off for free? I think of Forrester reports, Gartner reports that may not pass muster. The amount of substantiality of the work. So, are you reprinting a whole chapter? Are you reprinting 6 chapters of a book? Or are you reprinting 1 page? And so that's really an aspect. And then obviously, like I said earlier, what's the value of this use? Does this use diminish the market in some way? So just some thoughts there about using copyrighted work in a fair use environment. So now I want to get into some more of the specific torts that are involved within social media, and something that's probably the most litigated of all social media actions that are out there. And so within defamation, that's a broad category that includes libel and slander, but the basic elements are that the defendant's publication to a third person. So essentially, once you hit send on a tweet, that's published. Once you publish a Facebook status update, that's published. The material itself must be defamatory, and so it must in some way be, some sort of attack of character, of credibility, any of these things. It must be about the plaintiff, obviously. And it must be false. And so certainly this is one of the most common defenses, is that when proving defamation, that that truth is always a defense. So certainly keep that in mind if you're writing things. And then there must be some fault on the part of the publisher, and there must be damages. And this is really where it gets critical. If I write a tweet about somebody that I met on the side of the road, and the tweet is defamatory, and it is false, but there's no way that tweet actually had any sort of financial impact on them. Proving damage is going to be difficult. So there may be some response, but there's not going to be a lot of money at stake. So it's probably not even worth the whole lawsuit. So I'm going to go back to that for just a second. So just to tell one story, there was a Knoxville case in 2009 by a establishment called the Pizza Kitchen, and there were a number of things that were apparently going on, and this case is well documented within the local news. You can look it up, but essentially what happened, the store owner of the Pizza Kitchen was in a contractual relationship with a marketing or advertising firm, and when he was trying to move away from this advertising firm, he let them know that he was no longer wanted to do business with them, and the advertising firm said, that's fine, but you're going to have to pay us some amount of money in order for us to release your logo and your mailing lists and your Twitter account, and a number of different things, and basically held up the contract for a final payment. And very late at night, one night, the owner sat down and at Facebook posted a tweet that essentially said they were a bunch of crooks. X and X agency are a bunch of crooks. And that publication went on Facebook, and it also went on Twitter as well. And, who knows what happened. Maybe there was a few drinks that night, and, the owner was tired and frustrated and put this out there. Whatever the case was, early in the morning, about 6 hours later, he went in and deleted the posts. He deleted the post on Facebook and on Twitter. But unfortunately, it was too late for him. He was sued for $2 million for defamation, for libel. And so this case is still not resolved as far as I know. I did some research today and didn't see any settlement out there or anything to that effect. But what one of the questions was, what was publication? So if he posted this tweet that was out there or Facebook message at midnight, he had, say, 800 followers on Facebook, probably as many Twitter fans or Twitter followers, sorry. And when he puts this post out there at midnight, how many people actually read it? And so proving that there was publication, because publication requires that a third person actually reads it. And so between the hours of midnight and 6 a.m., who read this? And so that there's some matter of fact there that must be determined. And then what are the actual damages to this advertising firm for him putting this out there? And so there are a few things to look at that create some interesting legal questions. But from a matter of process question, it would be very different had he said, I think X and X advertising, whatever, are a bunch of crooks. And when it's a matter of opinion and not a matter of fact, that changes things dramatically. Now, trying to go through and prove that the statement indeed was true would be a possible defense, but in this case, that would be difficult and raise criminal issues, obviously, because he would have to establish that there was some fraud involved, and et cetera, et cetera. So, one of the interesting things that one of the attorneys raised along the way was there was no actual publication until the plaintiff brought the case to the public and shared the information, the written information. And that when that happened, that would be the first publication. I don't think that really went anywhere, but it was certainly interesting. So just to be clear, slander is spoken. Just a real easy way to remember. Slander is spoken, and libel is written. And so there's a well-developed body of law around libel, simply because of all the journalism issues that have been out there. for so many years. And so if you're a journalism student, you're well aware of what defamation is, and certainly how this impacts individuals. So one of the elements that I put back in there was the actual malice, that you sort of move in different spheres. When you are an ordinary citizen, it's a very low standard as far as being defamatory. But as you move into a greater spotlight, as it were, your level of scrutiny over the slander itself, or the libel itself, moves to a different level. So it has to have actual malice if it was going towards the President of the United States, somebody that had put themselves into the public spotlight. So within vicarious liability, there's some interesting information. And basically all that means is somebody else is being held accountable for the actions of somebody that they employ, or that they have given their agency to, or whatever, and given them a spokesman, for example, would be a great place where there's vicarious liability. And there's all kinds of lawsuits within vicarious liability. It's not an actual cause of action that you could sue somebody for, but it's a vehicle to attach liability from somebody that may not have very deep pockets to somebody that does have very deep pockets. And so there's a number of cases out there, but I was going to tell about one, Automeo versus Carphone Warehouse. And what happened in this case was kind of interesting. Two members of the staff, they posted a status update on a plaintiff's Facebook page, and he'd stayed logged in at Facebook and kind of walked away. And the status update said, "Finally came out of the closet. I'm gay and proud." And it was posted in the course of during the day of the employment, and it happened during their working hours, and the manager was somehow involved. So what the court found was the employer was actually found vicariously liable for the conduct that ultimately was sexual harassment. That was the real cause of action that was out there. But they imputed that back to the owners of the organization, because this manager was involved. These employees did this action within the normal course of employment, and so they weren't strictly prohibited within any policies from using social media, or using this person's social media account, or using somebody else's social media account. And so we'll talk a little bit more about that when we get to policy, but that's an interesting aspect of what vicarious liability does, and certainly how that impacts individuals. So the next thing is disclosure of information in terms of agreement. And so one of the most important things that's happened over the last few years has been a number of regulatory entities, the Federal Trade Commission, the Securities Exchange Commission, and the FDA have all come out with their own regulations about what must be disclosed within the use of social media. And so FTC has come out with the guides concerning the use and endorsements and testimonials and advertising, or they revised that, in order to include social media. And so basically any tweet even that endorses a product where there's payment in return, that must be disclosed to the general public, so that they have an awareness that this is a paid endorsement, and it's not just something that someone's saying for free. Well, this happens all the time within blogging, within social media, because this affiliate links that are out there, somebody's running a special on a piece of software, and it's a $79 piece of software. Well, some of these affiliate programs are paying back 70% of that value back to the person that's sharing this affiliate link. So they have to disclose in some way that this is not this is not just something that they truly believe in, and they're not receiving any compensation for it. So you'll find in a number of blogs when they're recommending services or software, there's typically a disclosure that this is an affiliate link, or in other cases that this is not paid. And so that's certainly very important. So one of the big things that's very popular, we've talked a little bit about within Facebook, is the idea of LikeGate. And so basically, in order to enter this contest, you must like this page. And so I think one of the things that we talked about when we were talking about contests was OfferPop and Rafflecopter and some of these services that remove that confinement that prevents people from actually coming in and liking a page, and it allows them to go into a form. They have to enter some information, but they don't have to like the page in order to enter the contest. And so that's become a bigger deal. And also, it can't be a lottery. You have to be very careful about entering these games a chance where it's going to interfere with state lottery rules and regulations. So we'll talk just a second about every site that you have needs to have some privacy policy and terms of service that covers the way that you are going to use the information that you collect on the site, and any of the terms that you're going to offer to any of the participants on the site. And so, first within privacy, if you are using things like Woopra, which we've talked about in the class, if you're using even Google Analytics, you need to let people know that their information is being tracked and how it's being used. The better privacy policies are going to be more simplistic. They're going to be easier to understand, and they're going to allow people to know exactly how their information is going to be used. I mean, the big thing that people want to know is they're not going to be sold into a spam list by joining your email list. And so, I think that's really important. Within terms of service, you want to drill into specifically when you get into paid software, when you get into any basic use of your site as an application, what you are telling people that you owe them. And so we talked recently about Google Reader, going down and Google's decision to take that down. Well, if you go back and read the terms of service, they owe the subscribers or users of the service nothing to use the Google Reader service. And so when they make the decision to take that site down, they're free to do that. If you haven't protected yourself, you expose certain legal actions to your user base to file a class action lawsuit against you. So just a few things to think about there. So this just found this to be an interesting case, this Bland versus Roberts. Sheriff's deputies worked for Sheriff A, and Sheriff B was the opponent in running for the office of sheriff. And so the sheriff's deputies, they all liked the opponent's page, and ultimately the opponent did not win the sheriff's seat, and so the incumbent sheriff fired all these sheriff's deputies, and they claimed that a like was protected speech, and the courts found that actually that's not true, that the like is not protected, and therefore he was free to fire them. One thing that's probably not talked about a lot within privacy is really this idea of intrusion into seclusion. And this happens a lot. You see it in locker rooms now where they don't want photographs within the locker room, so cell phone cameras are prohibited, things like that. And so that's certainly one very clear intrusion into seclusion. But the basic idea is that there's somebody that has no idea that someone is going to interfere, to record them, to transcribe them, whatever that may be. And so typically some defendant out there, or some potential defendant, intentionally, without authorization, invaded the privacy of somebody else. And so, I mean, like I said, within the gym and, taking pictures of people in compromising situations or inappropriate situations and publishing that information would clearly be one. The invasion, they say that it must be offensive to a reasonable person. I think that's probably a pretty good standard. It's got to be, taking a picture of somebody from the back of their head where you can't even tell who it is, on a train, may not qualify as unreasonable. But, showing a picture of somebody in a private situation, involved in some action or even not, but just showing them at a certain location, could certainly be unreasonable. The defendant must have intruded upon the person in some sort of private setting. And so this is really, this is one of the keys that this turns into, where if the plaintiff or the potential claimant was out in public at a ball game in front of everybody and you took a picture of them, there's not necessarily that expectation of privacy there. And so the final aspect or the final element is that it must have caused some emotional anguish. It must have caused some suffering to the plaintiff, which typically turns into damages. How much, what was this? Did you have to go to counseling because of this action? And so, that's this intrusion to conclusion. This is a huge issue with Twitter, with Instagram, and, publishing information that people had no idea that they were going to be shared out into the public. I think the ultimate question there is, where is that expectation of privacy? It seems like it's ever increasingly smaller, and so our privacy zones are very limited now. I read a stat this week that 33% of divorces involve Facebook in some way. Interesting. One of the most active body of law within social media is the discovery aspect around Facebook messages, and effective ways to deal with that. And so through e-discovery, there is no perfect way that the court is going to be able to find out exactly what those records were. And so there's, the chain of custody. You may have heard that in NCIS or whatever. So one possibility is the judge collects both parties' login information into Facebook, and they can go in there and read all their messages and read all the interactions, all of the comments, and then record that information and put that into a discoverable format. The other opportunity is to allow the opposing counsel to log in there. Well, all of these are fraught with all kinds of issues because at any time that there's someone in control of that information, they could make changes to the account. They could add false information. I mean, there's a variety of things that could happen. Not that occurs necessarily, but that's certainly a concern. So this has become a really big issue to try and figure out a good way to discover this information during these divorce hearings. The thing about it is, Facebook wants to have nothing to do with it. They don't want to be involved whatsoever, and so subpoenaing Facebook in order to get that information is fruitless, and typically will not yield anything. So I'm going to talk just for a second about business torts. This is not a really ripe area, but it's something definitely to consider. So one of the biggest things within social media is that you have individuals that work for a company, and they have lots of knowledge and information about that particular company. Sometimes they control the account. And before I get into the phone dog case, you have people that control manufacturing, they control process, they understand every nuance and every aspect of a business. And so just sharing that information out there and sharing those trade secrets can be an actionable offense back to that employee. And so when we get into policy and talk about that in a second, I think it's pretty important to think about what exactly is protectable and what's important there. With the Phone Dog case, Kravitz set up their Twitter account and ran it. And so at one point, the Phone Dog Twitter account was up to around 18,000 Twitter followers. And then Kravitz left the company and took all of those followers. And so Phone Dog sued Kravitz for those for taking all those Twitter accounts, and they had a valuation of $2.50 per follower, and so they sued him for $340,000. And so this case went on, and it was finally settled in December, and there's not a clear idea of what of exactly what the dollar amount was, but it was interesting to be able to state from their standpoint that there was this valuation $2.50, and that's an average. Obviously, you have some that are more involved and some that are less involved, but this is an often cited case when trying to figure out a valuation of a company's Twitter account, or sort of where that is. Facebook trends high on this number. I've seen estimations on Twitter as low as 30 cents a piece. So this I've never seen a lawsuit about, but it was from social media side. But this is one of those issues that you talked about in law school and said, you've probably never seen one of these cases. But just to kind of understand what the elements are, when there's a business contract out there and both parties are aware that there is a business contract, and then a potential defendant comes in and interacts with that contract and induces the company to break it. And so think about two salespeople. You have one that already has the contractual relationship, and you have a second one that's coming in trying to get their business. And so, they go and talk to him and say, no, we're under contract with Acme Company until 2016, and the company, and salesman B keeps coming back in and keeps trying to get them to break that contract. Well, when they induce that contract and say, okay, if you'll break that contract with them and come work with me, we'll give you, $50, whatever the amount is. And if they do indeed breach that contract relationship, then salesman A's company has a lawsuit against salesman B's company for whatever the remaining value of that contract was, plus treble damages. So 3 times whatever that value is. If that contract was $1 million, they'll sue him for $3 million. And so this happens in the business world some, but it happens quite a bit within social media, where you find out that somebody's within a contract and you're just trying to work that relationship. And if it ever leads to a point, certainly all of that becomes evidence that would be used in the case. So another action is certainly sexual harassment within the workplace. We saw some of this maybe with the Anthony Weiner twit pics, and that was not held as a harassment case necessarily, but there through Facebook and through Twitter, there's whether it's drunk tweeting or whatever the case may be, there is this when people are away from work and it's late and they have a lot of comfort in front of a computer, sometimes they say things they wouldn't say in person. And so the idea of sexual harassment through social media, it lends itself well to that. And so something to be very careful and to protect your employment environment with is important. I'm not going to say much about comment other than this is one of the most tested areas of the law. And so where you have a blog, or you have it, and this happens in newspapers quite frequently, you have a story out there and then you have a number of commenters out there. And so the question is, are those commenters' comments the responsibility of the publisher? Did they actually publish it because they made that medium available? In the early 2000s, 2005, this was even a huge issue, and the law was unsettled. Where this is now, typically, in most jurisdictions, is that the blog owner is not liable for the comments unless there's some alteration. And so I had a client that ran a blog, and they had some great comments coming in. They had one comment, very well articulated comment, about 4 paragraphs, articulates a case very well, and in the very last sentence says, "I believe that blank is FUBAR." Well, the client was uncomfortable with republishing FUBAR, and so just simply wanted to go in and delete that and then publish it. And clearly that changes it, because it's a republication at that point. At that point, it is now the responsibility of the publisher, not the original author. And not that there would have necessarily been a libel case from that, but certainly something to keep in mind. So in the area of employment, there's several issues that arise. And so certainly Title VII, that protects against race, color, religion, sex, or national origin in hiring, becomes a really important point in recruiting. And so using LinkedIn or Facebook or Foursquare or Twitter to essentially spy on potential applicants or recruits is a very dangerous game to play. And so to give an example, somebody applies for a job, they seem like a pretty good candidate, and the recruiter or the human resources person decides to go ahead and friend them on all their social networks and starts following them, and say they see a Foursquare check-in at a synagogue or at a mosque, and they ultimately decide not to hire that person because of their religious affiliation. Well, the onus goes back to the employer. If the person believes they were discriminated against, the onus is on the employer to prove that they did not do that. It's not on the part of the claimant to prove that it did happen. It's on the part of the discriminator, essentially, to prove that did not happen. And so certainly be very careful within that area. Now, this is probably the most interesting aspect of what's going on within social media and the law, is that the NLRB threw a complete wrench in social media policy and the way that employers actually deal with within social media at all. And so the basic gist of it is the NLRB came out against so many social media policies in the fourth quarter, well, really in December of 2012, and basically said, you cannot in your policy prevent any conversations between employees to congregate, to unionize, to voice their frustrations about the employment environment, to rally support, to expose the potential dangers that an employer is putting on them. And so it really changed this whole policy that said, well, I don't have to allow people to use social media on, during work time. And if anybody writes a defamatory comment about our work environment, then we're going to fire them. Well, NLRB said not so fast. And so as basic sort of guidelines, employers can't prevent coworkers from friending each other. They can't prevent employees from speaking negatively about the company, about the use of trademarks in a disparaging light of the company that they're with. This was, I think, really interesting that employees speaking to the press, typically in a PR situation, all employees are strictly prohibited from speaking to the press. But NLRB said, well, if they speak to the press on Twitter, if it's regarding their right to be able to communicate about their work environment or their OSHA standards or whatever that is, that's a protected right. You can't prohibit them from doing that. And then, really from using social media on company time. And so this has raised a lot of issues. It's not well defined. There's a case where a bartender complains about the patrons of the bar and how they're, he didn't get a raise and they're just a bunch of drunks that are, probably driving home drunk and yada, yada, yada. Well, his termination was acceptable because it really wasn't bringing in any complaints about the establishment of the company. But there are a number of cases that are very blurry legally as far as whether there was actually anything that would have anything to do with the employee complaining about their work relations or with their ability to unionize, et cetera. And so this is still to be worked out, but it's thrown a real kink and wrench into to social media policies. So we introduced Hootsuite. We've talked about that and how wonderful it is to be able to have multiple Twitter accounts and Facebook accounts and all these things to contribute to. Well, there are several instances out there where this is an area that has to be very well protected from the part of the company. And so just to give a couple of examples, I may have talked about some of these before, but KitchenAid had an employee that wrote this following tweet here to the main KitchenAid account through Hootsuite by using the wrong handle instead of picking the right account to publish. Certainly a problem, and engaged in political activity, and not a great presence for KitchenAid to its 500,000 Twitter followers at the time. This one's kind of fun, and I think it turned around a little bit. But the American Red Cross here again was posting to the wrong on Hootsuite, posting to the wrong account. Ryan found 4 bottle packs of Dogfish Head's Midas Touch beer. When we drink, we do it right, getting slizzard. Well, this went incredibly viral, and there was almost an immediate reaction from American Red Cross that was rather funny, and that owned the responsibility and said, essentially, we're not a bunch of lushes here, but we found the person. They are sober, and we've corrected their account. It was really pretty funny. But what ended up happening, Dogfish Head Beer jumped in and really found this to be an interesting opportunity to ride the wave. In fact, this bar in Austin gave away a pint of beer for every pint of blood that you could prove that you gave that day. And so it ended up turning this situation into a positive, which I certainly think was the right thing to do, and it worked out really well. And then finally, this Chrysler tweet raised quite a bit of rage. This was right after the 2011 or 2012 Super Bowl, when Chrysler came out with some really strong Detroit ads, and then this tweet came out, and the person was promptly fired. Imagine that. But that was from using the same client to publish to multiple accounts. All right, so kind of walked through a variety of different issues out there. Now I'm gonna end where we started, and that's really with a policy. The most critical aspect of the legal interaction of an organization within social media is to create a great policy. And so I'd say one of the most important things is to start from scratch. Don't start from scratch, is to use some of the wonderful resources that are out there. I've given you 2 links right here that will drive you to a resource, a bank of hundreds of corporate social media policies from all over the country. And so that's bit.ly policy-guidelines, policy-guidelines 2. Will take you to a number of different resources that will help out with that. I think it's really important when assembling a social media policy to have stakeholders from all throughout the organization involved, not just to have one single group that's the marketing group that's in there, but really have contributors from all across the organization to help give input and feedback towards how social media impacts them in their role, in their business. And it's very important to represent from the exactly who's going to be involved, who it's going to impact, and to be able to ask some questions that you otherwise wouldn't have. And so talked a little bit about FTC within each industry. Make sure that you have a great understanding of what those regulations that govern that industry are. And so I talked a little bit about FDA and talked a little bit about Securities Exchange Commission. So very important to follow those. Those can land individuals and companies in some really hot water. So we talked about trade secrets and what the dangers are. In the policy, I think it's really important to define whose property and ownership the trade secrets are. Who's the property? I put a Rolodex up here on the picture. In sales, that's commonly considered some sort of a trade secret, and if somebody just walks out with their Rolodex, that could potentially be a trade secret. It's changed so much, obviously, because of people just having their whole contact database in a number of different places, that the idea of stealing the Rolodex and walking out of the organization surreptitiously with their Rolodex, that's not really the case anymore, but continuing to call on those same relationships still stands. So this is a critical question for me as to whether you really lead with a guideline or a policy. And so the guideline's more the carrot, the policy's more the stick. I think the answer is both. For the people that you want contributing, you want to give them a guideline. You want to give them a few rules that are very short and succinct, gives them an idea of how to behave. And then you want a policy to really protect against some of these issues that we've talked about. So it gives you a right of termination. It gives you a right to correct some behavior and some action there. And then finally, once you've come up with something that you feel like is a good body of work, you need an attorney to actually go through that and make sure that there's no inconsistencies there, to make sure that you're covering some of the latest legal issues out there. And I probably wouldn't use this guy, but I love this commercial. This might be worth looking at. I put a link out there. It kind of shows sort of almost a life cycle of what a social media policy regulation looks like. It's a little complicated, and this is definitely an enterprise level solution. But I really like inside the circle, the define, promote, and enforce. It's really important to continue to enforce consistently whatever that policy is. Because if it's not enforced in one situation, then it can certainly be used as a defense when it is used. And so, just like any policy, it has to be used with consistency. So I have put out this template that you can use. It's a guideline that I use quite a bit and really like it. But you can see it's bit.ly jfloyd-social-guideline. And within this template, you'll find at least a pretty good start on what you might want to use as your guideline. At least it's a framework to start from. And so just to kind of come back, a few things that I would make sure that a social media policy had is that this should be a signed agreement. This should be part of the intake with the employee, so that they have a very clear understanding of what the social media policy within the organization is. I'd make really clear who's to speak on the behalf of the company. Said earlier, NLRB said that anybody can speak to the press, but specifically putting product information out, you want to have a pretty tight control over who are the brand ambassadors, who are the people that are out there speaking on behalf of the organization, and then to clearly define what proprietary and confidential information is. You want to have a good idea so that no one accidentally publishes information they shouldn't have. Maybe they didn't know. And so to be very clear and articulate about that on the front end can save a lot of grief down the road. The copyright infringement, I think, is very clear. Basically, I think one of the things we would cover, it's never use Google Images to find your images, because that's one of the areas you're going to lead into really hot water. Most of that information is copyrighted. Most of those images are copyrighted, and they're not available through Creative Commons licensing. Using Flickr and using the Creative Commons licensing can be, so that's something to think about. Have a defined scope of behavior, and what I mean by that is going back to the one case where the employees were ultimately sexually harassing another employee but were held vicariously liable. Making very clear about what the employee's responsibility on behalf of the organization is, I think, is very important from the front end. And so for 99% of the employees, it's nothing, unless you have a very open social media policy. That for most employees, it's going to be, your use of social media is your business. Disclosure, of anything that you do on behalf of the company is that you are not representing the opinions of this organization, and that you are writing freely on your own. So just think it's really important to have that scope discussion. And then go ahead with the editorial process that you have in place, especially for contributors and within the guidelines, is to have an idea of what that editorial process is. Most importantly, if someone is authorized to, or even if they're not authorized to, write on the behalf of the company, what does that look like for them? And what do they need to do as far as process? Who needs to review it? How does it get it published? All that information, so that that's well established. And then if there's a breach within that area, then you have some grounds for cause there. I think one of the safest things in some of the examples that I gave is within Hootsuite, don't allow personal account within that same account. Can be very helpful and beneficial. Anybody who's used Hootsuite will find themselves using the wrong account from time to time, and it probably will happen. And so the way to mitigate that risk is to remove any of those additional options that are out there. And then within HR, I just think it's really important to have some clear rules for recruiting. So I hope that's helpful. I hope that gives some information about what that legal framework looks like. And if there's any questions, feel free to leave some comments, and I'll be glad to answer them. Thanks.